56.
We're going to continue with this Court of Appeal review that denied Lucy Letby the right to appeal. We left off around paragraph 119. Further, when considering whether Dr. Evans' evidence was sufficiently reliable to be admitted, one of the criteria for admissibility identified in what is now paragraph 711 of the Criminal Procedures Rule 2023, it was material, as the judge pointed out, that Dr. Evans' expert opinion was given in ignorance of other potentially incriminating material relied on at the trial. Now, for the life of me, I can't see why that is relevant to paragraph 711 of the Criminal Procedures Act. Now, I know it's boring, but it is to me, and if that's the case, there's no need for you to listen to the podcast. But I think it's necessary to have a look at the expert evidence section, which is 7.1 of the Criminal Procedures Act. And the first paragraph, 7.1, admissibility generally. Expert opinion evidence is admissible in criminal proceedings if, in summary, A, it is relevant to a matter in issue at the proceedings. Well, I'd say Dr. Evans' evidence was relevant to the matter. It is needed to provide the court with information likely to be outside the court's own knowledge and experience. Now, that's a really interesting sentence on its own, which makes an enormous presumption. What is information? Because Dowie certainly supplied a lot of information which was not expert evidence. For example, in the case of baby I believe that the monitor was switched off that night. That's not expert evidence. C, that the witness is competent to give that opinion. And D, the expert opinion is sufficiently reliable to be admitted. And I have a huge issue with that. So we're not even out of paragraph 711, and already I've got two major issues. All doctors recognise that the gold standard reliable method of determining cause of death is postmortem. No doctor I know regards diagnosis by exclusion as a method of determining cause of death in the 21st century. And rather than diminishing the information about a patient about whom is difficult to determine, I've already cited the papers that say in almost half of all postmortems carried out in the UK over a 10-year period, the pathology report added new information as to the cause of death. Therefore, postmortem is so good as the gold standard method that it provides more insight into how and why a person died. Diagnosis by exclusion, on the other hand, is junk science, junk medicine, quintessentially alchemy. Factors which the court may take into account in determining the reliability of expert opinion, and especially of expert scientific opinion, meaning scientific data has to be reliable, usually to international standard organisation rules, before it can be used in an expert report. And for example, one of the big things that Dr. Evans said all the time, in fact, it's essential to the golden thread, that the babies were stable. And what data points did he use to determine whether the babies were stable? Well, capillary blood gases were used sometimes and disregarded sometimes as not being reliable. But the truth is that they're not reliable. Pulse oximetry for measuring blood gases, not reliable. All but one of the so-called blood glucose measurements in the case of BBF put into evidence were from bedside devices, which are not reliable. Only one blood glucose measurement was made on baby F, and it measured 999 millimoles per litre, which is wholly unreliable, being as it is over 100 times higher than an acceptable reading. The Roche Alexis immunoassay test used to determine the insulin C-peptide ratio in baby F cannot be used because the readings are 4,657 for insulin and less than 169 for C-peptide. But less than 169 is not a number. And indeed, Anna Milan has said since, that's the laboratory director at Liverpool University Hospital, that it could have been any number below 169. But the Roche immunoassay test can measure down to 3 picomoles per litre, begging the question, why didn't it do that? Why did it give a number that said less than 169 and not the exact number, which is well within the capabilities of the test? Therefore, with the blood glucose level being 999, verified, the C-peptide reading being less than 169, and the insulin reading being 4,657, that is not a reliable data set. In the case of BBL, the natural explanation for the finding of insulin at 1099 and C-peptide at 264 is transient hyperinsulinism, which is a fairly common finding in preterm neonates. The experts didn't explain that, which they should have, because it is a perfectly feasible explanation for the finding. These little babies make a lot of insulin when they're not supposed to. It can go on for 2 or 3 days, it can go on for weeks, it can go on for months. And there are different classifications and categories of the disease in the modern literature which perfectly easily explain the findings in the blood analysis of BBL. Excluding the findings of the postmortem is not acceptable in any analysis of a cause of death. Now, they will argue that they put into evidence an alternative opinion on the findings of the postmortem, but those opinions were not arrived at by the usual or acceptable methods either. Visualizing error in histology slides is not possible and is not a means by which the diagnosis of our embolism is made. Claiming, as in the case of BBO, that the liver injury was due to trauma inflicted at the hands of Lucy Letby, when we know that it was inflicted by a needle inserted by Dr. Beery. That makes that evidence unreliable. Well, it either makes it unreliable or it makes Section 7 of the Criminal Procedures Act a waste of time, one or the other. As I've said before, opinions will vary in emphasis when considering a postmortem, but they will not vary in their content. That is the entire purpose of the postmortem. So we have extent and quality of data, not reliable, and validity and methodology employed by the expert, not reliable. And I'm talking about all of the experts here. And then in Section C, it says, if the expert's opinion relies on an inference from any findings, whether the opinion properly explains how safe or unsafe the inference is, whether by reference to statistical significance or in other appropriate terms. Well, that pretty much rules out all of the radiological evidence given by Professor Arthurs, because the statistical likelihood of diagnosing her embolism from a postmortem X-ray is 0. And it is well known that it's very unsafe to infer anything from the finding of gas postmortem. You won't read an article in any medical journal or textbook that does not come with a health warning when interpreting the finding of any gas postmortem. And we know also that the reference to the statistical presence of Lucy Letby at these so-called events is also unsafe and unreliable, according to multiple experts. In Section E, the extent to which any material upon which the expert opinion is based has been reviewed by others with relevant expertise, for instance in peer-reviewed publications, and the views of those others on that material. In the show notes of this podcast, I have cited hundreds of papers that contradict the views of these experts, all of which have been peer-reviewed for publication, unlike any of the work of Dowie Evans. And also In the peer-reviewed work of Professor Arthurs, which is a substantial body of work, he makes no claims in any of his papers that X-rays, plain X-rays, one-dimensional back to front, are a reliable source of diagnosis for embolism, even though he does address that problem in many of his publications and explains the proper tool, CT scan, and its limitations for use in this scenario. But that was not the case for any of the babies in the Letby series. F. The extent to which the expert's opinion is based on material falling outside the expert's own field of expertise. Dowie Evans learned neonatology in the 1970s and the 1980s. He has never worked as a neonatologist, and the last time he worked in clinical practice was 15 years ago. He cannot possibly be up to date on the methods of treating preterm neonates and the complications of those methods, no matter what these judges say. We wouldn't allow Dowie to treat one of these babies. We shouldn't allow Dowie to make a diagnosis of one of these patients in a court of law. H. If there is a range of expert opinion on the matter in question, where in the range the expert's own opinion lies and whether the expert's preference has been properly explained, and I, whether the expert's methods followed established practice in the field, and if they did not, whether the reason for the divergence has been properly explained. And as I have explained, Dowie Evans' methods are unique to Dowie Evans. Dowie Evans' interpretations of findings or observations are unique to Dowie Evans. They fall outside the accepted inference from the observations and findings of the vast bulk of practicing neonatologists. And in 713, as far as I'm concerned, it gets even worse. In addition, in considering reliability, and especially the reliability of expert scientific opinion, the court must be astute to identify potential flaws in such opinion which detract from its reliability. For example, being based on a hypothesis which has not been subject to sufficient scrutiny, including where appropriate experimental or other testing, or which has failed to stand up to scrutiny, being based on an unjustifiable assumption, being based on flawed data, and relying on examination techniques, methods, or process which was not properly carried out or applied and was not appropriate for use in the particular case, or E. relying on an inference or conclusion which has not been properly reached. And it's my opinion that all of the evidence, the so-called scientific evidence, which the jury heard in the Letby trial, fails every one of those tests, A, B, C, D, and E, because it's junk science. And I'll leave a link to Judiciary UK, and you can go through it. And I think that you would probably agree with me that hypotheses, inferences that aren't inferences, they're deductions which are entirely different, and largely hypotheses. Putting forward one hypothesis or a very small data set of insulin C-peptide readings is not a safe or reliable method by which to infer poisoning by exogenous insulin. The data set is too small and it's open to perfectly innocent explanations because the data set is too small. In paragraph 119, the judges said that it was important that Evans' opinion was given in ignorance of other potentially incriminating material relied on at the trial. But again, I have no idea why that is pertinent to scientific evidence. The whole point of scientific evidence is that it's singularly uncorruptible or subject to qualitative and quantitative analysis independent of any other type of evidence. That is its sole purpose. So why is it important that Dr. Evans gives his opinion in ignorance of other potentially incriminating material? It's irrelevant. And it continues on. It was also material that there was other expert evidence which supported Dr. Evans' conclusions. Indeed, as the prosecution asserted, almost all of Dr. Evans' opinions were corroborated by another expert. And again, I have no idea where they got this from. Every one of the experts stated that the skin discoloration was not specific to our embolism. And in Professor Arthur's evidence, he stated that the only way that a chest x-ray could diagnose an air embolism was if it was taken at the time of the embolism and if it involved a huge quantity of air that would show up in a very characteristic pattern on a chest x-ray. Therefore, all other chest x-rays are irrelevant to the diagnosis of air embolism. We cannot have circumstantial scientific evidence. Histology is not a means by which you diagnose air embolism. Probability is not a method by which you diagnose anything from histology, as Dr. Martinarides did. And then they carry on and they say that we have no doubt that all of the criticisms of Dr. Evans, including those made by reference to the observations of Jackson L.J. in a different case, were capable of being dealt with within the trial process, or that the judge was fully entitled to conclude that ultimately, as with any other witness, it was for the jury to assess Dr. Evans' reliability having regard to all the evidence in the case. Which begs the question, why do we need DNA, fingerprint, ballistics, toxicology, acoustics, facial recognition, voice recognition, and all of these sundry other types of evidence used by experts in court? This doesn't make sense to me, particularly or as Section E of 112 says, especially about scientific evidence. And I've dealt with the so-called false premise in 122, which is a biased decision as far as I'm concerned, and I think if you were to ask Justice Jackson, he would agree with that he was referring in his complaint about Evans to both Evans the man as well as the letter put into evidence as proof of his unreliability as a witness. Moving on to Section 123 or paragraph 123, there is a degree of overlap between ground 2, challenging the judge's rejection of the submission of no case to answer, and ground 3, challenging the judge's direction that the jury did not have to be sure as to the precise harmful act or acts committed by the applicant against the particular baby. It is nevertheless convenient to consider them separately. This should be interesting. Paragraph 124. The submission of no case to answer was aimed at counts 1, 2, 4 and 16, cases in which the prosecution alleged that air embolism was the sole cause of death or collapse of the child concerned. So let's see what count 1, 2, 4 and 16 tell us. Baby A, baby B, baby D and baby M. And the principal evidence for all of these babies was the nonsense, pseudoscience, junk science, pink flitting rash that no one actually recorded at the time. And we've talked about this endlessly. There is no recognized, described, detailed physiological reason why any flitting pink rash might occur in a baby. One other pediatrician in the world, in the history of pediatrics, noticed this pink flitting rash in a single baby that he treated in 1989, and it hasn't been reported in any other paper for any other baby for any other reason since. And now we see it in at least 4 babies in the Letby series. And we have to remember that with baby M, this was in April 2016. Dr. Jairam claimed, when talking about baby A, which was in June of 2015, that he alighted upon the paper by Professor Lee describing this flitting pink rash almost a year before baby M's collapse. But he didn't record it in the record from June 2015, nor did he record it in April 2016. How does that make any sense? In his evidence, he said he became aware of the pink flitting rash in relation to baby A. One would presume then he would be on high alert for the appearance of this rash again. Yet when it happened almost a year later, in baby M, he didn't record it at the time of the collapse. And the methodology used by Dowie Evans to describe this was, he claimed, based on his knowledge of anatomy and physiology, which is not a method by which you can determine a cause of death after the event. Also, Dr. Evans made the claim that Lucy Letby had created a type of embolism time bomb by leaving an amount of air in the port of the giving set. That amount of air would amount to 0.4 mil or 0.1 mil of oxygen. It is impossible to see the effect of 0.1 mil of oxygen in a human body, including the body of a preterm neonate. No method, no peer-reviewed case reports, no mention in any textbook or any literature on medicine. The basis of this so-called expert knowledge is entirely from the imagination of Dr. Dowie Evans, and as a consequence, it is not scientific evidence and doesn't come anywhere near the standard obviously set out in Section 7 of the Criminal Procedures Act. But yet, here we are, and carrying on with paragraph 124 and counts 3, 5, 12, 17 and 20, cases in which the prosecution alleged that air embolism was a cause, in addition to other causes, of death or collapse. And the applicant, that's Letby, relied upon R versus Galbraith, 1981, and in particular upon the second limb of the test stated by Lord Lane in the familiar passage at page 127. This is what these lawyers do because a judge said something in 1981. It has to apply in 2023, which is probably the only branch of intellectual pursuit that works that way. And this is what the ruling said. If there is no evidence that a crime alleged to have been committed by the defendant, there is no difficulty. The judge will stop the case. 2, the difficulty arises when there is some evidence, but it is of a tenuous character. For example, because of inherent weakness or vagueness, or because it is inconsistent with other evidence. A, where the judge concludes that the prosecution evidence taken at its highest is such that the jury properly directed could not properly convict on it, it is his duty on a submission being made to stop the case. B, where, however, the prosecution evidence is such that its strength or weakness depends on the view to be taken by a witness's reliability, or other matters which are generally speaking within the province of the jury, and where, on one possible view of the facts, there is evidence on which the jury could properly come to the conclusion that the defendant is guilty, then the judge should allow the matter to be tried by the jury. So let's have a look and see what Mr. Galbraith was guilty of or not. Well, this is the Galbraith test, which is so far from science that it's laughable. If there's no evidence that a crime is committed by the defendant, the judge must stop the case. Question: how does the judge determine if there is evidence? So far, the only test for the reliability of evidence in the case of Lucy Letby is the appeal to authority. It is the unconventional opinion of a bunch of experts put together by Dowie Evans. Where there is some evidence, this Galbraith test goes on, but it is weak or vague. So this means that if you use the Galbraith test, you regard the evidence as weak or vague. If the prosecution evidence taken at its highest is such that a properly directed jury could not properly convict, the judge must stop the case. But again, this is an opinion of the judge as to the reliability of the evidence. But scientific evidence doesn't require opinion. It either is or it isn't. The question is very simple. Was there ever sufficient evidence at its highest in the case against Lucy Letby to determine if she had caused an air embolism, or indeed if any air embolism even existed? And the answer to that at its highest is no. Therefore, the judge should have dismissed the case. But we return to the circular logic, the appeal to authority. Because Darry Evans was an experienced paediatrician, that was sufficient for him to pass any test for reliability, which is against the spirit and the directions of Rule 7 of the Criminal Procedures Act, where they lay down in great detail what constitutes proper scientific evidence. And Darry Evans et al. Didn't come close to that. As I've said, you cannot have circumstantial scientific evidence. Avoiding weak or vague evidence is the entire point of science, whether that's in court or in an academic argument, or when building a mobile phone or a space rocket. It is the precision of science that allows those things to work, never its weakness or vagueness. But they allowed this to go ahead because they claim that if the strength of the prosecution evidence depends on the reliability of witnesses or other matters within the jury's province, and on one possible view of the fact there is evidence on which the jury could properly convict, the judge should allow the case to continue. And there we're back to our circular logic again. This makes the case definitely for the use of common sense, but it cannot make the case for the use of science. Science is either right or wrong, true or false, hypothetical, theoretical, but ultimately inexplicable, such as the origin of the universe, but it is never vague. Arguments in science can be weak, depending on the circumstance. For example, the claimed efficacy of a drug. There are many examples in medicine where the claimed efficacy of a drug turned out not to be the case, and in fact the opposite was true for some of these drugs. Thalidomide, a drug that was used to treat morning sickness in pregnancy, never had any evidential basis for its use, and despite the drug being banned in several jurisdictions, some physicians carried on using it. And it was only when it was properly evaluated by the scientific method that it was banned worldwide. In other words, the evidence that was used to make it look good was always vague. But when subject to method, that vagueness disappears. And as I keep saying, there was no method to Darry Evans' madness. I would argue, therefore, that the judge wrongly applied the Galbraith test to the scientific evidence used against Lucy Letby. And the purpose of this Galbraith test is apparently to preserve the integrity of the jury system and prevent judges from stopping cases too soon, which is a bit the same as saying, I haven't got a clue what's going on here, and I'm a judge, but maybe the jury will. No one in here can make head nor tail of this evidence, not even the experts. Professor Arthurs doesn't know anything about perinatal medicine. Darry Evans knows precious little about pathology. Dr. Marnarides knows nothing about radiology. Otherwise, he would be an expert radiologist. Modern medicine is so technical and so advanced that it should never be regarded as evidence sufficient for a jury to adjudicate upon. And to uphold this logical decision by Justice Goss, one has to argue that the expert evidence wasn't necessary at all. And I'll give you one example. The single judge in Letby's first appeal dismissed the case that the insulin evidence wasn't sufficient. And it clearly isn't. There are multiple explanations for the description of the babies and the data, substandard data that was used to assess those babies. And it's pretty impossible, because the data is so bad, to lay your money on which of these possibilities is most likely true. And the example is that during their deliberation, the jury came back and asked Justice Goss to clarify a point. They asked him to explain exactly how long it would take for the insulin to stop working once the infusion of the insulin had stopped. Now, I talked about this in another podcast, but I can't remember which one it was. Justice Goss told the jury that this point had not been dealt with in the evidence, which presumably means that, as he understood the evidence, he didn't believe that that point had been discussed by the experts. But the fact is, it had been. In the case of baby F, Professor Hindmarsh gave two conflicting answers about the duration of action of insulin given by infusion. In the one instance, he agreed with the prosecution that the fact that baby F's blood sugar rose once the infusion was stopped was paradoxical, because the infusion was primarily dextrose. Therefore, stop the dextrose, why should the blood sugar go up? But when Hindmarsh said, he believed that this paradox was correctly interpreted by the cessation of the insulin immediately after the infusion ceased. In the later part of his evidence, he said that it would take several hours for the insulin to stop working. Those are two different answers to the same question, and they're based on assumption as well. But both of the answers go to the question, how long does insulin continue to work when it's given by infusion? And the expert gives two different answers. The jury asks for clarification, and the judge tells them that these 2 points were never discussed in the evidence. But this was something that was really troubling the jury, so much so that they came out and asked for clarification. But they didn't receive clarification. Instead, they were essentially told that the question wasn't important. And to my way of thinking, this is what happens when you start to regard scientific evidence as not really any different from circumstantial evidence. At the very least, the judge admitted in his answer to the jury, that's Justice Goss, that the issue of how long insulin would continue to work after an infusion had stopped was vague or weak, when that's not really true. But the answer to how long would insulin continue to work after an infusion stopped is we wouldn't know unless we measured it. We could say, well, it could be anything between 2 and 8 minutes of a half-life. So for 4,657, that would give us a range of possibilities. Scientifically, and therefore in relation to expert evidence, an expert would say we would need a series of measurements that would describe for us how effectively this particular baby in this particular circumstance cleared insulin and C-peptide. And for every baby of this gestation whose physiology is not yet set in stone, so to speak, unlike Professor Hindmarsh's evidence, that dynamic would be different. It would be individual, and it would have to be individualized in order to answer the jury's question correctly. That's what science is for. That's why you get in your car, turn on the engine, put on your seatbelt, and drive safely to your destination. There is nothing vague or weak about the scientific and engineering standards the manufacturer of that car has to reach in order to sell it to you. We move on to paragraph 125. The starting point for Mr. Myers' submission to the judge was that expert medical evidence was fundamental to each of the allegations in those counts. It was then argued that the expert evidence relied on by the prosecution in relation to air embolism was insufficient for the following three reasons. Paragraph 126. First, it was submitted that the scientific basis for air embolism is so weak that it fails to provide the level of reliability required to support these allegations. Mr. Myers argued that the underlying consistency, coherence, and reliability of the scientific knowledge supporting the theory and diagnosis of air embolism did not provide a sufficiently clear and reliable basis on which to make a finding of air embolism in any given instance, which just goes to show that the defense didn't even understand the science behind air embolism, because there are methods by which you can be certain that a baby has an air embolism. The science is not inherently weak or vague, but like all science, it has to be applied correctly. And it's very clear that either the experts or the jury did not apply that standard. And the standard is relatively simple. 90% of air emboli occur in situations where a baby is subject to mechanical ventilation and or has a central line in place, which was the case in all of these babies. The argument that Myers should have made was, even if a proper method had led to the finding of air embolism in any of these babies, that method is not capable, in most cases, to be certain where the air came from. But the expert evidence was so bad that no one in that room, including the jury, seemed to know that. It's a very simple and very powerful point to make. Every one of those expert witnesses would have been forced to say that because this was a retrospective review of these patients, it wasn't possible to say for any one of them where an air embolism had originated. Lousy defence, lousy appeal. Paragraph 127. Secondly, it was submitted that the available research relevant to air embolism was extremely limited. It did not meet the requirement of paragraph 19A5 of the Criminal Practice Direction, now replaced, as we have said, by the similar provision of paragraph 7 of the Criminal Practice Direction 2023, and was insufficient to permit any expert evidence to be given. In this regard, it was submitted that what was needed was evidence establishing a sufficiently reliable basis for the diagnosis of air embolism. It was not enough for the prosecution merely to show that they had produced the best evidence which was available on a topic which has not been the subject of much research. Again, that is wrong. Now, the argument that I would have made was that I was able to locate 274 papers on air embolism in preterm neonates, which is a substantial body of work, albeit still limited. But the expert Barry Evans was only able to locate 19 papers, therefore further limiting a limited body of evidence. And that cannot be evidence taken at its highest. If an expert is only using a fraction of the knowledge available on a topic, it's evidence at its lowest. One paper that I quoted, which set out to actually show whether air embolism resulted from cardiopulmonary resuscitation, demonstrated that it did so in 89% of cases in preterm neonates. Therefore, that paper, not quoted by Barry Evans in his very limited selection of the limited data available, is sufficient on its own to clear Lucy Letby of these air embolism indictments. It is that simple. That's how a doctor gets through 20, 30, 40 patients a day relatively safely, and has done so for thousands of years. And paragraph 128. Thirdly, it was submitted that none of the expert witnesses who had given evidence as to the general theory or diagnosis of air embolism had sufficient clinical expertise to enable them to give expert evidence as to those matters. In summary, it was argued Dr. Evans had no clinical experience of diagnosing our embolism. He relied primarily on the Lee and Tanswell paper, and he gave inconsistent evidence as to the characteristics of our embolism. So let's look at that. Evans claimed that he had 19 papers. Evans used only one of them in court. The one that he did use in court, the Lee and Tanswell paper, does not refer to venous air embolism. It refers to pulmonary vascular air embolism, which, although it may have a similar effect on the body, is an entirely different disorder, and therefore was not an appropriate evidential basis for the assessment of venous air embolism. But sadly, that's not the argument that Mr. Myers makes. In part 2, Dr. Bohan had seen only one case of air embolism. She accepted there was very, very little literature relating to air embolism in children, and she too gave inconsistent evidence, including as to skin discoloration in relation to individual children. Again, that's the wrong argument to make, and it isn't the argument that Myers tried to make in court. It should have been very easy for Ben Myers to get a neonatologist to go on record under oath and cite the many papers that I have cited in this podcast to show that Evans' method of diagnosis was seriously flawed. Owen Arthur's method of diagnosis was seriously flawed. A line of gas on a postmortem x-ray is meaningless. And Dr. Bohan's ridiculous concept of air embolism in paragraph 88 of this ruling would fail you an undergraduate exam in medicine. A full unexpected collapse and the person dies, or it can present with a collapse where after resuscitation the person recovers, which is the diagnosis of a faint. 128, part 3, Professor Kinsey accepted that air embolism was not part of her expertise, and it was submitted that she was not able to call upon a reliable body of scientific knowledge to establish how air embolism in neonates presents by way of cutaneous features. This is the professor who told the jury that venous blood is blue. We'll see how the judges deal with this. Section 4, Professor Arthur's opinion that a postmortem finding of gas in a great vessel may, after excluding other possible explanations, be attributed to air embolism, was not based on any clinical experience and relied upon his own insufficient review of cases. Wrong argument. During cross-examination, Benjamin Myers should have asked during cross-examination of Professor Arthurs, by what scientific method did he reach the conclusion that the line of gas that he said was suspicious and unusual was air and not gas from putrefaction? And if there is a method by which you can distinguish air from putrefaction gas, and the answer to that is yes, there is. It's called mass spectrometry, and it will tell you precisely what that gas was, but it still won't tell you where it came from. And part 5, Dr. Marnarides could not or would not explain the mechanism by which air embolism causes death in a neonate. Well, bad question again, Mr. Myers, because Justice Goss had already told them in summing up that they didn't have to understand the precise mechanism by which death occurred. Instead, what he should have done was ask Dr. Marnarides how reliable is postmortem at diagnosing air embolism, and the answer to that is not very reliable at all. Therefore, Dr. Marnarides, you're saying that your methodology for diagnosing air embolism is not an accepted methodology for diagnosing air embolism. But he didn't ask that. Paragraph 129, it was therefore submitted that even taken at its highest, the prosecution evidence that babies had died because of an air embolism was not such that a jury properly directed could properly convict upon. Counts 1, 2, 4 and 16 should therefore be withdrawn from the jury. And in relation to counts 3, 5, 12, 17, and 20, the jury should be directed to disregard the evidence of aortic embolism as a cause of death or collapse in these babies. No, that should not be the argument. The argument is straightforward. Even in the unlikely event that these babies did die from aortic embolism, can you be certain to any degree, but particularly to the highest degree, that the origin of the aortic embolism wasn't iatrogenic? And none of these experts could have said yes to that question. They could have argued till the cows come home that each of these babies had or hadn't an aortic embolism, but they could not argue in all honesty or at its highest as to where that aortic embolism came from. In paragraph 130, the prosecution opposed the submission of no case to answer, arguing that the expert evidence as to aortic embolism was properly admissible. It was not evidence from the fringes of science and did not have to be given by someone who may be described as an expert in aortic embolism, a status which, it was suggested, it would be difficult, if not impossible, to attain, given that the stringent precaution taken by the doctors and nurses mean that the incidence of aortic embolism is very rare. Again, if you have 274 papers and you cherry-pick 19 of them, and you disregard the well-known fact that 90% of all aortic emboli are iatrogenic, doctor caused, then your evidence is from the fringes of science, literally from the fringes of science. And it would not be impossible to obtain expert evidence on how aortic embolism causes death, why embolism causes death, and where, in 90% of cases, aortic embolism causes death. 117 cases is a sufficient volume of knowledge to know that. But by not calling Professor Xu Li to give that evidence during the trial, the defense failed to create that fact in the evidence. Whose fault that was, I don't know, and I don't particularly care. But it was a very serious fault in Letby's defence. And again, in 130, because Lucy Letby took a course and because nurses and doctors try not to cause aortic embolisms, etc., all of which are entirely irrelevant, it is therefore submitted that the arguments on behalf of the applicant went to the weight of the evidence rather than its admissibility. The respondent emphasised the importance of the jury considering the totality of the evidence about a particular baby, including the expert evidence that the baby's death or collapse could not be explained by natural causes or any other non-criminal cause, which is utter bullshit. The jury were never told that the gold standard for the diagnosis of death was autopsy, and practically all of the expert evidence put into fact in this trial was more fringe than the Edinburgh Festival. Baby D died with pneumonia, not from pneumonia, despite the fact that the pneumonia and the inflammation caused by the pneumonia had torn the lungs apart. Psychobabble. And the same true for nearly every other one of the babies. And finally, in this episode 131, paragraph 131, in his ruling of the 2nd of May 2023, rejecting the submission of no case to answer, the judge referred to the passage in Orr versus Galbraith, which we have quoted above, and to the competing arguments of the parties. He expressed his conclusion that his decision as follows in paragraph 13 of his ruling. So this is Justice Goss falling back on the old Galbraith test. I am satisfied, he says, that there is a sufficient body of accepted expert medical opinion that the exogenous administration of air into the venous system can cause aortic embolism, leading to collapse and potentially the death of a baby. Because of the rarity of cases in which aortic embolism is identified in a fatal collapse, there is limited medical literature and research, and the level of clinical expertise is also necessarily limited. Completely wrong, Justice Goss. It's very easy for any doctor who reads the research to understand how, what, why, where and when aortic embolism comes about and kills. Carries on. Professor Arthurs and Dr. Marnarides were conspicuously careful not to go further than their specialist expertise would permit them, and emphasized any conclusions to be drawn were for those with clinical expertise. Begging the question, why were they there then? But again, Justice Goss is wrong. Professor Arthurs made it clear that only an X-ray taken at the time showing a massive embolism was of any value in diagnosing an air embolism. That's the science bit. And Dr. Marnarides, by implying that air embolism can be diagnosed by histology, was practicing fringe pathology from one doctor to another. I would have found such a claim in an autopsy report as bizarre in practice. The fact that the evidence was not of itself diagnostic of air embolism is not determinative as to whether the evidence of clinical neonatologists is admissible. Here we go back again to the very point of Section 7 of the Criminal Procedures Act 2023. It's not admissible if it doesn't follow a method that is peer-reviewed. That's how I read it. That's how I read the spirit of Section 7, and that's what the detail of Section 7 says. Such criticisms as are made by the defence of Dr. Evans and Bowen and the bases for their conclusions are not sufficient to render their evidence inadmissible. The assessment of the validity of the criticisms and the weight to be attached to their opinions is for the jury. And this is what we call the blind leading the blind. Criminal Procedures Act advises you to get experts into court to help the court in matters about which it knows nothing. And just by the fact that they are experts, or at least they call themselves experts, or in Dowie's case, don't call themselves experts, that authority is sufficient to allow admissibility, which it clearly is not if you read Section 7 of the Criminal Procedures Act. In the context of other circumstantial evidence, including the fact that in the cases of two other babies not the subject of these applications, someone in the NNU deliberately sought to harm them by adding insulin to their nutrition, and the circumstances and coincidence of the defendant's presence in the unit on each of the occasions of a sudden collapse of a baby in some cases at the cot or incubator side, and her admissions, I am satisfied that the evidence sought to be excluded is admissible, expert evidence for the jury to consider. It might be, but it's crap evidence from one doctor to another. And I wouldn't want any of my patients or my former patients to rely on this standard of evidence to make any clinical decision. In fact, I would be horrified if anyone used this methodology to determine whether a patient should have an operation to remove a tumour or not. I am also satisfied that in respect of counts 1, 2, 4 and 16, there is a body of evidence on which the jury, depending on their findings of fact and the inferences they draw, could properly come to the conclusion that the defendant is guilty. I refuse the application for those counts to be withdrawn from being determined by the jury. Similarly, I refuse the application that the evidence of air embolism should be withdrawn from the jury counts 3, 5, 12, 17 and 20. For me, this is like the boulder of Sisyphus, the ancient Corinthian king in Greek mythology who was forced by the gods to push a boulder up to the top of a hill, let it fall down again, and go back down and push it back up again, and to do this for all eternity. If the evidence is crap, it doesn't matter what the judge or the jury thinks of the evidence. If the data is corrupted, if the conclusions are bizarre, it doesn't matter whether they think they can happen or not. They can't happen. And the evidence against Lucy Letby is not scientific, is not the work of appropriate experts, and therefore is not admissible. That's only my humble opinion, as I say, from someone who has listened to experts all my life and had to make decisions on the basis of what they said. I can spot pseudoscience from 1,000 yards. I think For me, the court and the Court of Appeal have shot themselves in the foot by saying that there is limited knowledge about air embolism and then allowing that knowledge to be further diminished by the inclusion of only 19 papers and the opinions of a few experts who clearly have very unique opinions or views about air embolism, but they don't quote the body of knowledge. And so for me, the evidence put into fact by these experts with the help of advocates is a very pale shadow of the true knowledge of air embolism, and is, for me, outside the spirit or intention of Section 7 of the Criminal Procedures Act. There clearly wasn't enough pre-trial examination of the scientific base, which the judges allowed to be discovered, in effect, during the trial by people, that is, the judge and the jury, who don't necessarily have the requisite background and understanding of science to render this evidence as admissible under Section 7. But in my humble opinion as well, the defence made it relatively easy for the judges and for Justice Goss to get away with what is obviously a well-worn path, this Galbraith test, that for me is not relevant to proper scientific inquiry. The justice system in the United Kingdom could overcome this mess by developing a pool of experts that are essentially chosen at random and who work directly for the court. These experts could participate in a process which is based on the intentions of Section 7 of the Criminal Procedures Act and separate the flim-flam pseudoscience from the real deal before the trial even begins. This could even be done anonymously within the court system. It will be cheaper, more efficient, and definitely fairer. And as I understand it, the problem with experts in British courts is a long-running problem. And it's very sad that very decent people like the English have to put up with this silly and nonsensical system. So if we look at paragraph 135, just to finish off this section, it may be noted that the written grounds of appeal, it was argued that the Lane-Tanswell paper should not have been relied upon as it was by prosecution witnesses. The paper was said to be of little application to the trial of the applicant. It was not designed to explore the link between air embolism and skin discoloration, with discoloration being noted in only 5 or 6 of more than 50 cases of air embolism collapse reviewed, only one of which was bright pink vessels against a generally cyanosed cutaneous background. Moreover, the subjects of the Lane-Tanswell paper were not comparable in age, medical condition, or clinical circumstances with the infants concerned in this case. It was submitted that the paper, therefore, could not support the evidence of prosecution witnesses to the effect that skin discoloration is a feature of air embolism. And in paragraph 136, in his oral submission, Mr. Myers now, however, argues that the specific skin discoloration mentioned in the Lane-Tanswell paper, bright pink vessels against a generally cyanosed cutaneous background, can properly be treated as diagnostic of air embolism, but that no other type of discoloration can be regarded as diagnostic or pathognomic of air embolism. Mr. Myers submits that the prosecution expert evidence provided neither a research basis nor clinical experience sufficient to enable reliable identification of any specific cutaneous discolorations which would be diagnostic of air embolism. The witness, he argues, unjustifiably treated a wide variety of cutaneous discolorations as diagnostic. And in 137, the respondent submits that the judge's decision refusing the submission of no case to answer is unassailable. Mr. Johnson argues, as he did before the judge, that in relation to each of the babies concerned, evidence relating to air embolism was only part of the overall circumstances relied on as proving the prosecution case. He points to the evidence showing that each of the babies concerned collapsed or died for no apparent reason, that they exhibited skin discoloration of a highly unusual kind, often described by very experienced doctors and nurses as being unlike anything they'd ever seen before, and that natural causes could not provide a credible explanation. He adds that when the prosecution expert witnesses were preparing their initial reports, they did so without reference to other features of the circumstantial case against the applicant. 138. Mr. Johnson further submits that Dr. Jairam's evidence as to the discoloration which he observed on the skin of baby A, noted in paragraph 51 above, could properly be accepted by the jury as fitting the description to the Lane-Tanswell paper. Dr. Jairam had not initially mentioned seeing the discoloration he later described, but only did so after he read the Lane-Tanswell paper. It was suggested to him in cross-examination that he had not in fact seen what he described. That suggestion was refuted by Dr. Jairam, and Mr. Johnson submits that the jury were plainly entitled to accept the doctor's evidence, as it was only when he read the Lane-Tanswell paper that he realised the full significance of the striking discoloration he had observed. 139. Save that the description of skin discoloration did not feature in Dr. Jairam's clinical notes, we observe in passing that there appears to have been little evidential basis for the allegation implicitly made on behalf of the applicant that Dr. Jairam had made up this part of his evidence. We also note that no similar allegation appears to have been made against the father of baby O, who, as set out at paragraph 93 above, describes the child's veins as being bright blue. For me, all of this indicates just how wrong these judges are, and it's very obvious that they do not understand science at all. But yet, by their status, they can give false opinion because, as non-scientists, it can only be opinion based on erroneous assumptions and false attributions. They stated when they quoted the paper, Lane-Tanswell paper earlier on, that Dr. Lee or Professor Lee had attributed the pink flitting rash as a manifestation of the direct oxygenation of red blood cells in the vasculature from the air embolism itself. So let's look at two options with regards to that, which are really important. If the attribution is true, which it isn't because it has not been scientifically proven, but if it was, the circumstance in which it happened was in the context of massively high ventilatory pressures, which created an air leak that allowed gas to directly enter the blood vessels and bypass the pulmonary bed. That is not what happened to the Lucy Letby babies, according to the main witness, Dowie Evans, who put into evidence that the Letby air embolisms passed through the heart and into the pulmonary bed, and therefore did not make connection with the vasculature of any of the babies directly. So, if the attribution is true, it is not true for venous air embolism. And rather than arguing that the babies didn't fit into the same category as the Lane-Tanswell babies, Myers would have been better arguing that the mechanism described in the Lane-Tanswell paper and used by these people wasn't the same as the mechanism used by Lucy Letby. He should have forced Dowie Evans et al. To calculate the amount of oxygen needed to produce that pink flitting rash over a prolonged period of time. And the 5 mils and the 0.5 mils of air that Letby is said to have injected into these babies was never going to be enough to produce that rash or any other rash. And if we take a circumstance where Professor Lee's attribution is not true, then the pink flitting rash cannot be attributed in any way to air embolism. It could just as easily be attributed to the presence of the underlying medical condition, which we call respiratory distress syndrome. And as to the father's description, he is describing what is generally known as cyanosis. Cyanosis simply means a lack of oxygen for any reason. It is not pathognomic or even remotely pathognomic of any disease. And remember, blood is never blue. What the father witnessed was an optical illusion. And for the judges to try and conflate these two observations, that of the father and that of Dr. Jairam and others, is a grave mistake, in my opinion, and simply makes the case again that this evidence isn't admissible. An optical illusion should not be admissible as evidence in a criminal trial, but the judges don't realise that that's what they've actually done. And by illusion, I mean illusion, something seen or observed that isn't actually there. I can't think of anything further from evidence than something that isn't there. And I know I go on like a broken record about this, but it is at the heart of the matter. The judges are not fit to discern if the evidence is factual or confabulated, in my opinion, but yet they did so. And I think that their attempt to downplay the importance of the Lane-Tanswell paper to this trial is a little bit disingenuous. The only two witnesses that didn't mention the Lane-Tanswell paper were Dr. Marnarides and Professor Arthurs. They used a different form of pseudoscience to reach the same erroneous conclusion, or at least they put into evidence information that was not sufficiently clear for the judges, obviously, and the jury to infer any reasonable conclusion from. So we'll leave this rather long podcast now, and we'll pick up again in the discussion of these paragraphs in the next episode. Bye.